Thank you. I'm being told by the organizers that we are in fact running late and that we cannot have more than 5 minutes more. So I'm going to have to limit it to also respect this request. That essentially means I have seen two gentlemen who want to ask questions. If we have two questions and three answers, it's not going to be 5 minutes. So I'll take one question first, and I'll see if it can possibly be accommodated within the amount of time. I'll allow the next one. Otherwise, I'll have to simply bring it to a close with one question. I think that I saw you first, so with apologies to the other gentleman, I'll take you.
Thank you. Robert Thompson, Fellow at Trinity College. I'm intrigued by the difference between the EP and the Council in terms of the level of transparency, particularly in the legislative decision-making process. And my question is, given that the EP is so much more transparent than the Council during that process, and now the norm is that the EP and Council have to negotiate to approve a law, doesn't this differential put the EP at an enormous disadvantage in the ordinary legislative procedure?
Whom would you like to have this question?
Perhaps either Mr. Driessen or
Mr. Maes?
Yes.
Okay, fine.
I think this council is for you.
Go ahead.
I'm not really sure it's I'm not sure whether the facts are as simple or as straightforward as they seem at the surface, as these things are in legislative matters. Things seldom are. From a recent experience with a co-decision, ordinary legislative procedure, I've seen a coalition of one member state with pretty much all the MEPs of that nationality working together, and I had the more than dark suspicion that the MEPs were briefed by their specific member state. Do forgive me if I won't go in many more specifics. In practice, the EP tends to hold its own pretty well in negotiations with the council. Let me tell you, and it's simply by having an assembly organized by political group. It's hard to do, which are all politicians. It's hard to keep anything confidential in the parliament, and there are some rules in place now for those parts of the parliament that deal with external relations, that they have to respect some security rules if they want to have access to confidential information, classified information, where of course there are rules in place, and they also have to be abided by everybody dealing with that information. In terms of legislative matters, in practice, again, the Parliament tends to hold its own pretty well and tends to be fairly successful in driving through its will in legislative files, in my experience. So I'm not sure whether the differences that you perceive are in fact actually leading to the Parliament being any less effective. I think I'll stop it with there so we can take another.
Thank you. Let me hear the question before I say we can go forward, because it's a big question. We might not be able to do it, but there was another gentleman who wanted to speak.
No, my question's been answered.
Okay.
Yeah.
Wow, that's wonderful. Thank you. That's very good. This is helping. Okay. Listen, let me just bring this thing to a close by making two very brief comments. I have found this to be very rich. I hope you found it also. The comments from the people in the panels, the members of the panel, would have prompted me to say a great deal about very many of these topics. But I think that the advantage of this particular composition of this panel was that it gave you a chance to be able to see also the union and how it operates. Different institutions have different priorities, different kinds of readings, if you please, of the law itself.
Sure.
And this is as it should be. of course it becomes ultimately a part of the evolving democratic process to in fact work it out, and then ultimately we have the courts, which are the authoritative interpreters of the law. So I think you saw very clearly how all these issues on this very difficult issue of how do you arrive at a judicious balance between the right to access and the right of protecting data, which is in fact something that the courts have not sufficiently addressed yet. They're now probably going in the direction of doing it, and we'll be having more fun, if I can use that term, in the years to come. The second point is, I think, that the one that was made by Mr. Patch, which is very important, okay? What will facilitate access in the years to come will not only be the legal framework, but will be the technical means taken to allow or to facilitate access, at the technical level. In other words, the registers, the way in which the information is constructed. And it seems to me we're moving in a new era whereby the quality of information will become the great point of contestation within the institutions, not the information itself. So we'll move past the point where an ingenious way of addressing a complainant was, you want information, here's 10,000 pages, take it, and then you figure it out. Drowning the complainant in information, to the next stage where in fact it will be incumbent upon the institutions, as they apply practices and rules of good and principles of good administration, to ensure that the information is processed in such a way so as to make it readily accessible and readily intelligible to the user. And that has very significant technical implications I cannot go into, about how you present it, in what form you present it, etc., etc. And I think this has clearly been touched upon. I think it's a very important point that we may leave you with, thanking you again for being here and for listening to us, and thanking, of course, both the Transparency International and the Irish Society for European Lawyers for convening us. Thank you all and have a good evening.
I'll just say a few words before we wrap up entirely. I'd like to thank the panel again, and I have a few more thank yous to make before we leave. Kieran was a little worried about the number of empty seats here tonight. I'm surprised so many people turned up at all, given all the talk of transparency during this general election campaign. I think people are exhausted by listening to politicians talk about the need for transparency and greater accountability.
But we're not politicians.
I'm aware of that, but I'm not sure so many others outside could have. I think that the positive to come away with from the election campaign is that there is an emerging consensus on the need for greater transparency and the role of transparency in holding governments to account, in promoting citizen participation and in preventing corruption. But I think it's this kind of discussion, this platitude-free discussion that is needed in the aftermath, in the next few months of this, or in the aftermath of this general election. And I know I've learned a great deal of go away understanding how access to information or the challenges facing us in promoting access to information in Ireland and across the European Union, what those challenges are, and in providing guidance to people who come to us looking for official documents as we open up a new transparency help desk here in Dublin. Again, I'd like to thank our panel, Ombudsman Diamandouros and our other panellists here tonight. I'd like to thank Kieran Toland and the Irish Society for European Law, and my colleagues at Transparency International Ireland, David Dunn and Clarissa Unger. Have a great night. Thank you.
Thank you very much.